Today we're going to get into the judicial fraud aspect of my case, of why the law liar judges lied. I went all the way to the Supreme Court of Canada, to the top court in the land. And the thing is about the top court in the land, when they bring a judgment, when I make an application for leave to appeal, they can, before you can even get to argue it, they got to actually decide if they're going to actually let you come and argue it. Then they either you're granted to go there and argue it, or they dismiss it. But in my case, they're just going to dismiss it, because in my appeal, I said that the judges committed outright fraud, and there's no way that their colleague law liars just protect the integrity of their colleagues' lies instead of the integrity of the rules of court of Alberta. The Supreme Court of Canada, they don't even have to give you a reason to the judgment like the Court of Appeals do. Ian Binney, Rosalie Ciberminabella, and Laurie Charan just dismissed my case outright because they're a pack of law liars that are trying to protect the integrity of their legal system, which is not a system of justice. It's just a system to protect the integrity of the law liars' lies instead of protecting the integrity of the rules of court and the boundaries of law. I want to show you the pictures of these of the smug and condescending law liars from the Supreme Court. They can be more smug and condescending than the appeals court judges, and the appeals court judges were smug and condescending, and they committed outright fraud. Now let's get into the lies of the appeals court judges, which is Carol Conrad, Peter Martin, Alexander Park. They brought up some lies. I'm going to take you through the three-page, it's 3 pages, which basically the judgment's on 1 page and 1 sentence long, and that was about it. But the thing is, there's so many untruths there. Not even half-truths. It's just a total outright lie. If anybody was to listen to this video and they were to, read the judgment and look at the appeal book, it's like, well, they brought up so many things. So many things not taken from the appeal books, not taken from my volume 1, my pleadings and final documents. They never had anything taken from my from the evidence, the transcript from trial, and they never had anything taken. They never took it from the exhibits, or they never actually took it from my factum, my 7-page factum. They brought up, they said things that were never there or never existed. I want Alison Redfern, who is actually just trying to cover up because she's a law liar too, and she's an elected law liar. That's the Justice Minister of Alberta. And of course, she wants to protect her law liars' lies because those are her colleagues. But before we get into the 7-page factum, we're going to go into the judgment, and I'm going to show you what's different about the judgment. I want Alison Redfern to request the Canadian Judicial Council to do a judicial inquiry. I want those judges to show in the inquiry, well, where did you come up with this in the appeal books? How did you find that? What constitutes this? But the thing is, they're from the Law Liar Society, and the Law Liar Society is all about, well, we have to this constitutes a lie because we're law liars, and we have to protect the integrity of the law liar's lies and instead of the integrity of the law-abiding citizen and the rules of court and the boundaries of law. So let's proceed with the judgment. In the next video is going to be all about the law liar's lies. That's why I wasn't granted my appeal, because there was a whole paper trail of law liar's lies, a whole slew of paper trails of law liar's lies, like Kathleen Linton saying that I have no basis for, because I was ambushed, and because Justice Honor deprived me of sections 28.1 and 28.2 of the Canada Evidence Act, and I also should have not been deprived of sections 6.1 and 6.2 of the Canada Evidence Act, because I have a difference. I have a difference because I have memory problems, because I have brain damage caused by MS. And my last MRI scan showed lesions all the way deep down into my brain. And I can't If I'm well versed on something, I will do very good at it, but when I'm confronted by an ambush, I can't deal with something suddenly because I need it to be filed into my long-term memory. Something in my short-term memory, I just do not do that good against it. And that's why Karen Horner and Rhonda Sales ambushed me. So let's get on with the judgment. I'm going to show you what's wrong, what's different in my appeal books, mainly the Factum. The Memorandum of Judgment by the Court 3-panel judges of the Court of Appeals of Alberta. Justice Carol Conrad, Peter Martin, Alexander Park. That was a fraudulent judgment with so many things based on fiction that did not come from the appeal books, did not come from any of the appeal material that I produced. Only I did. So they can only take the facts from my appeal books, which was all the facts that was from the trial. They can only take it from my Factums, the 3 volumes of my appeal books, and they did not. This is the first page of their Memorandum of Judgment. It's 5 paragraphs long, so let's get into the first 3 paragraphs. This is paragraph 1, 2, and 3, so let's read it. And all the lies are underlined in red, so you see that there's 4 lies there, but let's read on from the first. It says, Mr. Achtem appeals a matrimonial property order. He submits he was prevented from adducing material evidence and that he was taken by surprise by evidence produced at trial. With the result, he was denied the proper opportunity to prepare and meet his case against him. Moreover, Mr. Achtem says the judgment is unreasonable and should be set aside. Both parties represented themselves at trial and on appeal. The appeal proceeded without oral argument. Mr. Achtem alleges he was denied fair trial because he was unable to call an employee of the bank who dealt with the mortgage, and that was supposed to be placed on the house purchased by the parties when they moved from Calgary to Redcliffe. He says this evidence would have shown that his wife had told the banker she was thinking of separating. That paragraph's a lie. She did not tell the banker she was thinking of separating. She told the banker she was going to separate prior to moving, months prior to moving. So I don't know where those judges found that in the appeal book, and I want to know. And I want a judicial inquiry to find out. I want them to show me where they found that. I want Alison Redfern to trigger a judicial inquiry and say, where do they find that? Let's get on reading. The appeal, the employee had phoned Mr. Achtem and asked him about the separation, explained that a separation might affect whether they received a mortgage. Mr. Achtem then phoned his wife and she denied a statement. And she denied the statement. She did not deny the statement. She admitted to the statement, and she admitted that to the bank employee. So that's a lie. So it's 2 lies. Let's get on to lie number 3. According to Mr. Achtem, this evidence would have shown that his wife had told the banker that she was thinking of separating. That's a reiteration of the first lie, the 3rd lie. So that's 3 lies. Let's keep reading. He submits this evidence might have changed the trial judgment. Mr. Achtem also submits he was denied a fair trial because he was taken by surprise by documents. Yes, I was taken by surprise by documents. But what the lie is, at the very end of that sentence, it says, documents adduced at trial. Documents could not be adduced at trial pursuant to Alberta Rule Court 158.5 subsection 1E. Including emails sent to him by which his wife used to cross-examine me on. Well, I wouldn't have minded her using those, cross-examining me on those exhibits if they had been served pursuant to the Canada Evidence Act, where they could have only been served 7 days ahead of trial. But that's the boundary that judges jumped over, because they have to protect the integrity of the trial judge from depriving me of the Canada Evidence Act and deprive me of the rule of court of adducing evidence. So we're going to have a quick look at the rule of adducing court. It says right there, the it could not be adduced at trial unless it was produced into the action prior to even coming to trial, and it wasn't. So let's go to the factums, and I can't show you where they could have not found this in the factums. I can only show you what the factum said, and it doesn't coincide with what they're saying in their judgment there from what's underlined in red. Thank you for watching part 1 of this video of the judicial fraud of the 3-judge appeal panel from the Court of Appeals of Alberta. Please go on to part 2. If you're already in an auto playlist, then it'll just kick forward to the next video here in a minute. Or if you're not, then just please go to part 2 by just going to the video response right down below this video. Then you'll go move forward. Thank you.